Welcome to the Mandamus Lawyers Podcast, a legal education series about federal court remedies for immigration delays. I'm Mary, and I'm here with my co-host, Aaron. Today we're addressing one of the most common concerns people have about mandamus lawsuits. Will suing the government hurt my immigration case?
This is probably the question we encounter most frequently. People understand that their case has been delayed unreasonably. They know there's a legal remedy available, but they're afraid to use it. They worry that filing a lawsuit will anger the government and lead to retaliation.
It's a natural fear. The government controls the outcome of their immigration case, and the idea of suing that same government feels risky.
It does feel risky, but the fear is based on myths and misconceptions rather than how the system actually works. Today, we're going to address those myths directly and explain why filing a mandamus lawsuit does not hurt your immigration case.
Let's start with the biggest fear. Will the government retaliate against someone who sues?
There is no evidence of retaliation, and USCIS has no lawful authority to retaliate against applicants for filing a mandamus lawsuit. This is the most persistent myth, and it's not supported by how the immigration system operates.
Why not? It seems like they could if they wanted to.
Several reasons. First, the adjudicating officer who decides your immigration application is almost never the same person dealing with the lawsuit. The lawsuit is handled by lawyers at the Department of Justice and the U.S. Attorney's Office. The USCIS officer reviewing your green card or naturalization application is a completely different person in a completely different part of the agency.
So there's a separation between the litigation side and the adjudication side.
Exactly. The officer deciding your case may not even know a lawsuit was filed, and even if they did, they are bound by regulations and policies that prohibit considering improper factors in their decision. Retaliation for exercising a legal right would itself be unlawful.
Some people worry that suing the government will make them look like a troublemaker or suggest they have bad moral character.
This myth confuses exercising a legal right with doing something wrong. Filing a lawsuit to compel agency action is a lawful remedy expressly provided by Congress. The Mandamus Act and the Administrative Procedure Act exist specifically so that people can seek judicial relief when agencies fail to act.
So it's not like breaking a rule or doing something improper.
Not at all. You're using the legal system exactly as it was designed to be used. Courts have repeatedly recognized that applicants have a right to seek judicial review of unreasonable delays. There is nothing about filing such a lawsuit that reflects negatively on an applicant's character.
Does USCIS consider whether someone filed a lawsuit when evaluating good moral character for naturalization?
No. The good moral character analysis looks at things like criminal history, fraud, failure to pay taxes, and similar conduct. Filing a civil lawsuit to enforce your legal rights is not a negative factor. It's not even relevant to the analysis.
What about the fear that the government will simply deny the application to punish the applicant?
There is no evidence that this occurs, and the structure of the adjudication process makes it unlikely. USCIS officers must adjudicate cases based on the law and the evidence. If an applicant meets the eligibility requirements, the application must be approved. If the applicant doesn't meet the requirements, it will be denied. But that would have happened regardless of whether a lawsuit was filed.
So the outcome is based on the merits, not on whether there's pending litigation.
Correct. The adjudicating officer's job is to determine whether the applicant qualifies under the relevant statute and regulations. The existence of a lawsuit doesn't change the eligibility criteria, and officers have no lawful basis to deny an otherwise approvable case because of pending litigation.
Are there any safeguards against arbitrary denials?
Yes. Denials must be explained in writing, and most denials can be appealed or challenged in court. If USCIS denied a case without a valid legal basis, the applicant would have recourse. Officers are aware of this oversight, which provides an institutional check against pretextual denials.
Here's another concern I've heard. Won't filing a lawsuit actually slow things down because now the government has to deal with litigation instead of just processing the application?
This is backwards. In practice, the opposite happens. Filing a lawsuit typically accelerates the case rather than slowing it down.
Why is that?
Because the lawsuit creates accountability and urgency. Before the lawsuit, your application was one of many in a queue with no particular deadline. After the lawsuit, an assistant U.S. attorney has to get involved. The agency has to explain the delay, and there are court deadlines to meet. Agencies routinely prioritize cases with pending litigation precisely because there's now external pressure to act.
So the lawsuit actually moves things forward.
In most cases, yes. Many applicants see their cases adjudicated within weeks or months of filing a lawsuit, after waiting years with no action. The lawsuit is often the catalyst that finally gets the agency to act.
Some people are skeptical of the whole process. They think lawyers are exaggerating the benefits of mandamus lawsuits just to collect fees.
Healthy skepticism is fine, but look at the actual outcomes. Immigration attorneys who handle mandamus cases track their results, and the data shows that the vast majority of cases result in agency action after the lawsuit is filed. This isn't theoretical. It's based on hundreds and thousands of cases across the country.
What explains the high success rate?
It's simple. Agencies don't want to litigate. Defending a lawsuit takes time, costs money, and requires agency personnel to gather files, prepare declarations, and work with Justice Department attorneys. In most cases, it's far easier for the agency to just adjudicate the pending application than to defend years of inaction in federal court.
So the incentives actually favor resolution.
They do. The government has every reason to resolve these cases quickly once litigation begins, and that's exactly what happens in practice.
Is there a perception that only problematic cases need mandamus lawsuits?
Some people assume that if their case has been delayed, there must be something wrong with it, something the government found that's causing the holdup. And they worry that filing a lawsuit will draw attention to whatever that problem is.
Is that a valid concern?
Usually not. The reality is that many cases are delayed for bureaucratic reasons that have nothing to do with the merits. Files get lost, cases fall through the cracks, background checks get stuck in queues, officers get reassigned. There's nothing wrong with the application, it just hasn't been touched.
So the delay doesn't necessarily mean there's a problem.
Right. And when a lawsuit is filed, the agency finally pulls the file and reviews it. In many cases, they find a complete, approvable application that simply sat unattended. The lawsuit prompts the review that should have happened long ago.
Some applicants are intimidated by the idea of federal court. It sounds serious and high stakes.
Federal court is serious, but that's actually a good thing for applicants. It means the process is formal. There are rules the government must follow, and there's a neutral judge overseeing everything. Unlike dealing with an unresponsive agency, in federal court, you have rights and the government has obligations.
What about the risk of losing?
It's important to understand what losing means in this context. If the court grants the government's motion to dismiss, the case ends, but you're no worse off than before you filed. Your immigration application is still pending. You haven't lost any rights or eligibility.
So the downside is limited.
Yes. The worst-case scenario in most mandamus cases is that the lawsuit doesn't succeed and you're back where you started. You don't get deported for filing a mandamus case. Your application doesn't get automatically denied. You simply continue waiting, as you were before. Except now, you've at least tried to get a resolution.
Let's talk about what actually happens in these cases. What does the track record look like?
Immigration attorneys and firms that handle mandamus cases report very high rates of success. The vast majority of cases result in agency adjudication after the lawsuit is filed. Many cases resolve within 30 to 90 days of service. There is no data suggesting adverse outcomes for applicants who file suit.
Why does filing work so well?
Because the calculus changes once litigation begins. Before the lawsuit, there's no consequence to the agency for continued delay. After the lawsuit, there are deadlines, court oversight, and the possibility of an adverse ruling. The path of least resistance becomes adjudicating the application rather than defending the delay.
And the outcomes? Approvals versus denials?
The outcomes track what you would expect based on the merits of the underlying cases. Applicants who are eligible get approved. Applicants with genuine issues may get denied or receive requests for evidence. The evidence shows that the lawsuit doesn't negatively affect the outcome. It compels the agency to finally make a decision that should have been made earlier.
If the myths aren't true, why do they persist?
Fear of the government is deeply ingrained, especially for immigrants. Many applicants come from countries where challenging the government can have serious consequences. The idea that you can sue a federal agency and not face retaliation seems almost too good to be true.
So it's a cultural and psychological barrier.
Partly. There's also misinformation that circulates in immigrant communities, well-meaning friends or relatives who advise against rocking the boat. And some applicants have had negative experiences with government agencies in the past, which makes them cautious.
How do you overcome that fear?
By looking at the facts. Talk to attorneys who handle these cases. Look at the outcomes. Understand how the system actually works, the separation between litigation and adjudication, the legal protections against retaliation, the track record of success. The evidence overwhelmingly shows that mandamus lawsuits help rather than hurt.
Is there ever a situation where filing a mandamus lawsuit might not be advisable?
There are some cases where caution makes sense, but not for the reasons people usually worry about. For example, if the applicant knows there's a problem with their case, a criminal issue, a fraud concern, an eligibility question, they should consult with an attorney before filing. Not because the lawsuit will cause retaliation, but because they need to understand their overall situation.
What else?
If the case hasn't been pending very long, a lawsuit might be premature. Courts apply the track factors, and if the delay is within normal processing times, the case may not be strong enough. Filing too early could result in dismissal.
So it's about timing and case evaluation, not fear of retaliation.
Exactly. The decision to file should be based on a realistic assessment of whether the delay is unreasonable and whether litigation is the right strategy, not on unfounded fears about government retaliation.
Let's summarize the key points from this episode.
First, there is no evidence that the government retaliates against applicants who file mandamus lawsuits, and USCIS has no lawful authority to do so. The officers adjudicating immigration applications are separate from the attorneys defending lawsuits, and exercising your legal rights is not a negative factor in any immigration determination.
Second, filing a mandamus lawsuit typically accelerates rather than slows down your case. The lawsuit creates accountability and urgency, prompting agencies to act on applications that have been ignored. The track record shows that most cases are adjudicated after litigation begins, often within weeks or months.
Third, the risks of filing are limited. If the lawsuit is unsuccessful, you're no worse off than before. Your application remains pending. The myths about retaliation, spite denials, and government punishment are not supported by the evidence or by how the system actually works. The decision to file should be based on a realistic evaluation of your case, not on unfounded fears.
Thank you for listening to the Mandamus Lawyers podcast. Mandamus Lawyers is a law firm focused exclusively on federal court litigation for immigration delays. Visit mandamuslawyers.com.